All right, if I didn't already call it, we'll call it again. People versus Curtis Ryan Peterson, file 22-13450FH. Appearances from council, please.
Good morning, Your Honor. Corey Wiggins on behalf of the people.
I'm Jeff Harrison. I'm here on behalf of Mr. Peterson. He has joined me at the table. Your Honor, we are here for sentencing today. For a couple of reasons, I would like to make a record.
Sure.
And formally make a motion to withdraw Mr. Peterson's plea in this case.
Okay, go ahead. You may be seated, sir. All right, Mr. Harrison.
As the court is aware, there was a great deal of discussion, negotiation, communication between the parties prior to the resolution of this case via Mr. Peterson's guilty plea. In one of those discussions in this very courtroom, both Mr. Wiggins and I noted that his scoring would likely be 36 to 90 as a habitual third. However, when the actual score was compiled by Mr. Van Adel, and I'll get to that in a minute, it dovetails with some objections I had as well. Okay. PSI. As the court can note from the PSI in this matter, the actual scoring is 72 to 180. Now, that is not a slight discrepancy from what was the tacit understanding of the parties while negotiating the plea. In fact, it is exactly twice as much as we had contemplated. Now, the dissecting this is relatively easy. Both Mr. Wiggins and I scored this case out at the onset of the proceedings and did indeed score it at 36 to 90. However, some subsequent events could lend credence to an argument that points ought to be scored on OV-19 for some conduct on Mr. Peterson's behalf whilst on bond. That would increase the scoring, if you will, on the B grid to the 51 to 85 box. That's really for a different day and time. I just wanted you to have the entire background. The motion to withdraw is based on case law. There's a great deal of case law that has been developed with regard to the habitual enhancement. And the original pronouncement was the Boatman case that said, hey, you don't have to tell them if there's a habitual enhancement. It's not a separate crime. Well, that was overruled in subsequent cases, the Cade case, for example, that said, well, of course, an enhancement such as a habitual offender is important information that a defendant ought to know.
Did he not know that there was a habitual offender?
Well, I'm getting to that, Your Honor.
I see it on the felony information.
Correct. That's not our claim here. Just
okay.
Maybe I buried the headline.
All right, go ahead. Let's get to that.
Buried the lead.
Yep.
The culmination of those cases, a Michigan Supreme Court case called People versus Brown, and specifically overrules Boatman and Cade. That's why I like it. It's 492 Mich 684. It's a 2012 opinion.
Is that a Mich you said or Mishat?
Mich. It's a Supreme Court case.
492-684.
Indeed.
Copy.
What Brown says, finally, it kind of brings all those cases together. It specifically overrules the first two. It says, basically, it makes an acknowledgement. Look, you can make a motion to withdraw a sentence or a plea within 6 months after sentencing. We choose to do that before sentencing for reasons which should be obvious, but perhaps they're not. So I will elucidate further. The point that Brown makes finally and distinctly is by not telling a defendant the potential maximum sentence because of his or her habitual offender status, a trial court is not advising of the true potential maximum sentence. Now, again, this case, Brown talks about habitual offender enhancement.
Did I not tell him?
You did.
All right.
And that's not our claim here.
All right. So,
but by that same logic, the fact that we were relying on what turned out to be I hesitate to say erroneous information, incorrect information accomplishes relatively the same thing. It does not provide the defendant with the idea of what the true maximum potential sentence is in his case.
Is there any case law that says?
There is not.
All right. I'm
That's
sorry,
why-
hold on, let me finish the question. Is there any case law that says he has to know what the sentencing guideline ranges are?
I don't believe so. I believe that is an administrative rule change pending by the SCOW right now.
There's a consideration of a House bill, I believe it's a House bill,
Right.
not a Senate bill, that requires parties to agree as to what the guideline range is, but that's not the law yet.
I agree with you, it isn't.
I sit on the crim law committee and I'm pretty sure we have made our opinion known.
Right, and I think that sort of logic dovetails nicely with what we're talking about here, okay? The court rule itself sort of refers to a catch-all provision. In other words, it would render a court's opinion that a plea shall not be withdrawn subject to considerations of manifest justice and that sort of thing. I didn't say that very well, but I think I made my point. So while this case, including this case, and there doesn't appear to be subsequent jurisprudence on that issue, does not specifically talk about the sentence guidelines, they are incredibly important pieces of information that a defendant should be allowed to consider in making a decision to enter a plea. Now, I guess my point would be diminished in no small measure if the discrepancy here was only a slight one. If it was a difference between 5 to 23 and 10 to 23, I submit to you, that may not be enough to tip the scale. However, the case here is literally the bottom end is 36 months and as opposed to 72. I don't think that gives the full and complete picture to the defendant and would warrant this court allowing him to withdraw that plea. Thank you.
Was this case set for trial?
It was.
Yeah,
Morning
I recall.
of trial, Mr.
I
Peterson
recall.
entered a plea.
Indeed.
Yep, I recall. All right. Mr. Wiggins?
Your Honor, I don't believe the defense has stated any legal ground to allow the defendant out of his plea based on a miscalculation of the guidelines. Now, Mr. Harrison is correct. He and I did score and had agreed on the scoring, but that had nothing to do with the sentence. As a matter of fact, I can tell you all the way through, there was never a sentence agreement in this case. And if I recall correctly, and my notes indicate, which is something we'll need to correct in the PSI, there was an agreement at the time that he entered the plea that I would not seek to add a conspiracy charge as the trial moved forward if I thought that it bore out. What this sounds like, and I don't want to put words in Mr. Harrison's mouth, but what this sounds like would be more of an ineffective assistance of counsel claim.
That's the only claim I could hear.
And I don't believe we've even risen to that fact or to that.
There's two prongs to an ineffective assistance claim underneath Strickland, and it requires that there be an error and that the error cause some prejudice. Because of my status, now we don't know what the result would have been at trial.
Right.
Had we gone to trial, there wouldn't be any impact. You'd be looking at the same sentence theoretically.
Correct.
Yeah.
And I'll also just throw this out there, perhaps. We haven't even done any challenges to scoring yet. So
Yeah,
we don't know
I'd rather
there is a challenge that might bring it back down to those guidelines. But I think for right now, I'm going to oppose the motion. I don't think there's legal grounds to that. And I don't believe that the test has been met for ineffective assistance.
Let's go ahead and take a look here, Mr. Harrison. Are there any challenges? Let's start off with the offense variables because there's only two. When we look at offense variable 19, which you referenced, this is where there is a scoring for 10 points, alleging that the defendant, quote, otherwise interfered with or attempted to interfere with the administration of justice or directly or indirectly violated a personal protection order. So we know the PPO portion is not applicable. What was Mr. Van Acklo, what was the sorry, the court recognizes Mr. Sean Van Ackle before the court today, the agent who prepared the PSI. Let's take a look, Mr. Van Ackle. Why was OV 19 scored? I see that that's going to be covered on CFJ 284, page 2.
Your Honor, my rationale for scoring OV 19 was essentially his conduct on bond, moving GPS tether, absconding, and resisting arrest.
Let's talk a little bit more about that. So he was on bond? Is that right? In this case?
Yes, Your Honor.
And then while he was on bond, he was placed on tether, correct?
Yes.
And then while he was on tether, he removed the tether device.
I would say,
Okay,
that's correct.
let's take,
I believe he showed up for testing, took off, and then cut his tether short period after.
I'm going to also note today on the record that the court did receive on Friday a sentencing memorandum submitted by the defense. I also took a look at that. Well, let me keep going here for just a moment on this issue. Yeah, I see that the bench warrant was issued back on January 11th of this year. And see a note here in the file. Oh, hold on. Looks like on February 3rd, defendant pled guilty to the bond violations and bond was revoked. All right, so that explains why offense variable 19 was scored. Let me take a quick look at the bench book for offense variable 19. Court notes in case entitled Smith, People versus Smith 488, and I'll note that it appears on page 202 of that ruling, that it talks about how conduct after the sentence offense was completed, which seems to support the court's interpretation of offense variable 19 because it's interfering with the judicial process. So I think offense variable 19. Well, any argument, Mr. Harrison?
I don't think I have a colorable one in light of Smith. The prior argument would be that there would be an element in the sentencing offense itself, but I'm aware that Smith covers over that.
I'm going to say that offense variable 19 is properly scored. Do we have any issues with the prior record variables?
We do, Your Honor.
All right, let's talk about those.
Specific to PRV 6.
Okay.
It doesn't say anything on, I'm sorry, on 284 page 2, it doesn't indicate which offense is contemplated in scoring that for being on bond for a misdemeanor offense. So if you turn to the back, can you look at
CFJ 284, probably page 10?
page 10 and then back to page 9. If you look at 14 of 16.
14 of 16 is the current offense.
Exactly.
And so the offense date occurred on or about November 11th, 2021.
November
And
1st.
November 1st. Thank you for the correction. You are correct. Looks like for conviction 13 of 16. Well, he would have, yeah, that conviction wasn't, it was arrested on July 25th, 2021. That wasn't resolved until February 10th, 2022.
If you go to 12 of 16 on that same page, Your Honor.
All right.
That is the case number listed in the narrative portion under 14 of 16.
14 of 16. Let's take a look.
Shows an offense date of July 12, but it shows an arrest date of February 9 of 22.
Okay.
Does not appear that he.
Now, does that mean that number 12 doesn't apply, but wouldn't 13 of 16 apply?
Yeah.
He would have been on bond if not for 12 of 16. He would have been on bond for 13 of 16.
He entered a plea in 13 of 16 on February 10th of 22.
Right, which, and the arrest date, yeah, so that means that he was on bond.
Your Honor, I don't believe he was.
All right, go ahead.
I have the register of actions from Sovcit County,
Oh, okay,
and it shows that on that case, the offense date was 7/25. The complaint was filed 8/5/21. There was a notice of arraignment provided to the defendant on July 26th
okay,
to appear for an arraignment on 8/9. However, he never appeared.
all right,
So we go through, and it finally looks like he was arraigned at some point. I believe it was in February of 22.
so it would have been after the offense date here.
It was.
So he wasn't on bond for 13 of 16.
Correct.
So that takes us back to the question raised by Mr. Harrison as to 12 of 16. The arrest, I'm sorry, yes, sir?
12 of 16, I had the register of actions for as well. My understanding from Agent Van Acknell, the reason he scored it for being on bond was because the register of actions showed that a PR bond was set on 8/4/21. However, the warrant was never actually served until February 11th of 22.
February 11th.
Correct, of 22.
So there's a question there as to whether or not he was on bond.
I suspect what the court did, and I haven't been able to confirm it, but I suspect when they received the warrant, they set the bond at that time. And then if he was arrested, he'd have a roadside bond. So I don't believe he was on bond, but I do have some arguments as why it should be scored when Mr. Harrison is completed.
All right, so this is getting muckier, but that's okay. That's why we go through things slowly. I'm more than willing to make the appropriate correction if there's an improper scoring. And I think this is the best approach to that so far. Mr. Harrison, as to the scoring of PRV 6, thank you.
My motion would be to have that scored at 0 as opposed to 5.
Right, so
I believe Mr. Wiggins.
Mr. Wiggins, anything further to argue on PRV 6?
Yes, Your Honor.
Pursuant to People v. Lyons, which is at 222 Mishat 319, it's a 1997 case. That's LYONS. It states that the guidelines do not state that the 5 points to be assessed are only for those enumerated circumstances. In People versus Andres, which is 269 Mishat 414, 2006, and that's ENDRES. The court had found that the defendant was not on probation at the time that he had committed the offense, and there was a date range for the offenses. However, it did find that he had committed an MIP during the date range of the sentencing offense, and that he was sentenced to fines and costs, and that those fines and costs were still owing at the time that the offense had occurred. So therefore, the court found that he had a relationship with the criminal justice system because those fines and costs were still owing, and therefore it was appropriate to score the 5 points. I did find that Mr. Peterson had, and I believe it is in offense 11 of 16, which was a domestic violence third pled down to the jostling. I believe it's that case. The defendant still owes fines and costs in that case, Your Honor, and for that reason, I believe he has a relationship to the criminal justice system. It is a misdemeanor relationship based on People v. Lyons and People versus Andres. I believe it would be appropriate to score that at the 5 points.
If I may, Your Honor, I think the guidelines book is pretty specific. It does use the term relationship to the criminal justice system, but only in the catch-all paragraph for which 0 points are scored. So I guess on the surface, it might beg the question, well, what kind of relationship is contemplated to put positive, or I guess in this case, negative effect into the scoring for this particular defendant? And those are clearly defined categories: on probation, delayed sentence status, or on bond awaiting adjudication or sentencing for a misdemeanor. It does not give any sort of expander at the end of that or some other relationship with the criminal justice system. It simply enlightens us as to, under these circumstances, this is the extent of the relationship of the criminal justice system that allows the points to be incurred for this variable. And I'll admit I haven't read Lyons or Andres, but it does not seem consistent with the clear language of the statute to expand that into other areas that clearly were not contemplated when the guidelines were enacted.
Pursuant to MCL 777.56, the actual statute itself reads, for parenthetical 1, prior record variable 6 is relationship to criminal justice system. It continues to read, score prior record variable 6 by determining which of the following apply and by assigning the number of points attributable to the one that has the highest points. So the place where it uses, quote, relationship to the criminal justice system, end quote, is inside the body of the parenthetical 1. When I look at the subparagraphs, it scores points for if the offender is, wait, we looked at 10 points, right? Is that what, or is it 5 points? 5 points, thank you. 5 points. 5 points is scored when, quote, the offender is on probation or delayed sentence or on bond awaiting adjudication or sentencing or a misdemeanor. So adjudication or sentencing. Mr. Wiggins, regarding 12 of 16 again, could you explain to me that register of actions?
12 of 16.
Yeah, that's the one where you said there was the assault and battery, there was the charge, offense date of July 12th, 2021. The arrest date may have been on February 9th. But you said there was a PR bond issued?
Let me make sure I got the right piece.
Sure.
245. The warrant. The offense date was 7/12 of 21. The complaint was filed on 8/4 of 21. On 8/4, the district court set a PR bond with the condition of no contact with the victim, filed the outstanding warrant, and the warrant was served on February 11th of 22.
The offense date in this particular file again is?
November 1st, 21.
Okay, all right. So the court will make a finding of fact that the defendant was not on bond for offense 12 of 16, nor was he on bond apparently for 13 of 16. Is that correct? He wasn't, that's the one we already covered.
Right, correct.
So that means the court must make a ruling and a finding of fact as to 11 of 16. The court understands the argument made by Mr. Wiggins. He does have fines and costs outstanding. The court, however, is going to rule in favor of the defendant and strike the scoring, PRV6. Take just a moment, that changes the total PRV from 50 to 45.
And it does change the guidelines.
Okay. Now, are there any other challenges to the PRV scoring?
I don't believe so, Your Honor.
Okay. That means we have a guideline range of, one moment, I think it's the 5185, but then that's increased because of the habitual offender third to 127. So he range, it's a score, I'm sorry, a range of 51 to 127. The maximum punishment of 480 months still remains in effect. Are there any other challenges to the scoring of the guidelines, Mr. Harrison?
There are not, Your Honor.
Mr. Wiggins, anything on behalf of the people regarding the scoring of the guidelines?
For scoring purposes, no, Your Honor.
All right, so now we're going to turn to, that leads us back with Mr. Harrison's argument, his motion. His motion was to withdraw the plea. Well,
Yeah,
anything further to add, Mr. Harrison?
I do not, Your Honor.
Mr. Wiggins, I've already heard argument on this. Anything further to add, sir?
In regards to the motion withdrawal?
Yes.
No, Your Honor.
Okay. The court recognizes that there has been some criminal efforts at criminal justice reform, and some of them have been passed. One of them that is raised is not yet law, and that is they talked about requirements that guideline ranges be reached and it be memorialized. That hasn't yet been passed. I might have my own professional opinion about where that's at and where it's likely to go or not go, but that doesn't matter. The point here is at today's time, it's not law. Also, when the court takes a plea, the court takes a plea and asks every single time. You probably have spoken, it says something to the effect of, you probably spoke with Mr. Harrison. He's probably talked to you about the Michigan sentencing guidelines and applied his experience and give you an idea as to what the court may sentence you to. However, has he or anyone promised you exactly what the sentence would be? And we wouldn't be here if the defendant had said, yes, somebody promised me. So I also note that this would arguably be at most an ineffective assistance claim. Well, the ineffective assistance, as I mentioned earlier, requires two prongs. One, that there be an error or omission, and that resulted in a prejudice. Well, it's a bit difficult for the court to address prejudice because guideline scorings are just estimates, and the court, they are not determinative, and the court can exceed either above or below the guidelines. This case was set for trial on that particular day, and the defendant made admissions. And quite honestly, I'm going to leave it at that. The court does not find there to be grounds for granting a withdrawal of the plea. Therefore, the motion made by Mr. Harrison is hereby denied. Allocution, Mr. Harrison?
Oh,
wait. Oh, I thought we were done. I'm sorry. Are there any other amendments or corrections, Mr. Wiggins?
There is, Your Honor. On CFJ 184, 145,
page 1.
There was that agreement that we would not seek to add a conspiracy charge.
Yeah, I meant, thank you. You mentioned that earlier.
Okay.
We will add Mr. Van Ackmo, prosecutor promised not to, or agreed to not bring an additional charge of conspiracy to deliver.
Yes.
Thank you.
All right. On 284, page 11, offense 16 of 16. I talked with Mr. Van Ackmo about this, and it does state that the misdemeanor is scored, but he indicated he did not score it. That he puts that in there for future use to show that it is a scorable misdemeanor.
So 16 of 16, we're just going to say scorable.
Correct.
But not scored today.
Right.
Let's do scorable in future, just so it's clear that it's not being counted. All right.
That is all I have.
Mr. Harrison, any other amendments, corrections, or objections to make to the pre-sentence investigation report?
I don't believe so, Your Honor.
Allocution then, Mr. Harrison.
Sorry. Judge.
Oh, sorry, yes, sir.
Since we made the changes to PRV scoring, I think
Yep.
this language on 284 page 1 about him being on bond.
Oh, yes,
Oh,
I'm
That's
sorry.
throughout the report.
Thank
it
you,
just
Mr.
mentioned
Bernardo.
Being on bond would have to get changed.
Thank you. So for status of the offense for conviction 14 of 16, which is the pending conviction, we will strike that language underneath status at time of offense. Thank you. Mr. Harrison, allocution?
Indeed, Your Honor. I'm sorry, I'm chomping at the bit a little bit to get to this. I guess from the outset, I'd like to make another statement. In so doing, I don't mean to
It's okay, go
either
ahead.
be accused of being far too cute or disingenuous when I say this, but the habitual third scoring remains discretionary with the court. That's not so much a new statement of fact, it's just a reminder of the state of being that it is. You have also, in addition to the PSI, in addition to our sentencing memo, you should have received letters of support, primarily addressing Mr. Peterson as a person, as a man.
There's a letter from Josh Simmons. Was there another letter?
There should be a letter from Stephanie Aponte as well, Your Honor. I have copies if everyone would like to see that. It was my understanding that that was disseminated late last week. But if that's not the case, I'll be happy to share.
1 second. In the information that I received a statement from Marina Bigger, a peer recovery coach, one from Josh Simmons, and the sentencing memorandum. I did not receive the one that you just mentioned.
Well, if I may approach, Your Honor, here's
You
a
may.
copy of it.
I'll just take your copy. Thank you.
Thank you.
Yep, the court
Appreciate
will
your
take just a,
consideration.
thank you, the court will take a moment to read it. All right, I've read that letter, and again, I will, I'm not gonna put it into the file, and I did read through the entirety of the letter.
Well-
Mr. Harrison, you may continue, sir.
A common theme of all of these letters is talks about and addresses the quality individual that they see in Mr. Peterson. And then they subsequently, virtually all three of them go on to state that, yes, he made mistakes here. And his primary mistake was becoming addicted to methamphetamine. And then this case arose in his quest to feed his habit and supply methamphetamine to a person he believed was a friend, but was also operating as a confidential informant for the Traverse Narcotics team. I think more evidence that the court has already seen as to what kind of person Curtis Ryan Peterson is his demeanor before you on the date that he entered the plea. As the court noted that day, he was forthright, he was mature in his responsive behavior, he didn't equivocate, he didn't try to deflect blame for what happened. He took full responsibility and did so in a straightforward and, dare I say, highly effective way. Now, the reason I wanted to get to those aspects of the case up front is that it seems kind of petty. It seems like a really small point to say he properly addressed the court. It seems to be a relatively small point that his girlfriend thinks he's a good guy, okay? But when you look at the totality of the circumstances, there are a number of things that when you add them up, I believe dictate that the sentence in this matter be focused toward the lower end of the guideline. Now, obviously, the prior recommendation was for 120 months, which based on the previous scoring was within that guideline. That's certainly not true as we stand here right now, however. It does reinforce the idea that the focus is on what you could say would be the upper end of the guideline as opposed to the lower. Clearly, as you can see, there's ample mention in the PSI of Mr. Peterson's extensive criminal record? Well, really, we can talk about two aspects of that that aren't mentioned in the PSI. First of all, one, despite, and that's where the terminology comes in, the nomenclature. How do you describe this thing? Despite the extent, if you will, of his record, his PRV remains at 45 points. Again, Your Honor, I acknowledge that that seems like a rather scant argument. But as this court is well aware, we often see defendants with scores of well over 100 points for their PRV. And for what it's worth, Mr. Peterson is not one of those guys. The second thing that I wish to emphasize about that is this is Mr. Peterson's first arrest involving controlled substances, first felony charge involving controlled substances. Has he had some trouble in the past? Well, he certainly has. As noted in the report, he's been in prison before. Again, that does not necessarily translate, at least not in my mind, to what I would call a fairly unremarkable PRV score of 45, at least in this court. And this case involves one instance of a delivery. And he has more than eloquently explained to everyone, the court, to Mr. Van Andel and to me, why he did what he did. And I think his statement is relatively compelling in that regard as well. Look, here's what I did, and here's why I did it. What that reveals to me or reinforces in my mind is that he's taking responsibility for what occurred. He's telling you because he wants you to know that this was not his game, not his occupation, not his usual manner of behavior. I think when you look at all of those little points that I just made in a positive way, or in I dare I say an appropriate way, they show you a drastically different picture than the original recommendation did. The original recommendation was for a 10-year prison sentence, despite the increase in the guidelines. As the point is made, I believe, rather fervently in the sentencing memo, we don't believe that original recommendation was anything approximating an apportionment sentence for what occurred in this case. Now, we move that down a peg, so to speak. We're in the next box over on the sentencing grid for B, for the guidelines. And we're at 51 to 85, or the discretionary habitual 127. And it's apparent to me, at least, that the perspective ought to be on the lower end of that guideline range. I wish there was a way that I could stand before you and say, Your Honor, this should be a downward departure. Obviously, that was our initial foray into this, was something around a 3-year prison sentence was contemplated. And I guess the shift in thinking that I've had to wrap my brain around before today, and even more so after the court's ruling in this case, is something like 4 years an appropriate sentence? In other words, the very bottom of that guideline at 51 months. And my gut reaction, my conclusion is that it is. And I would encourage the court to likewise take into consideration everything we've discussed today, everything that's contained in Mr. Peterson's statement, the 2 letters, the sentencing memo, and more importantly, its own observation of this gentleman in his court, and arrive at a sentence that is appropriate, proportional, and near the bottom of that guideline. Thank you, Your Honor.
Mr. Wiggins, on behalf of the people, sir.
Thank you, Your Honor. A couple of things stand out to me as Mr. Harrison was talking. And one is that he took responsibility. Well, he did until he found out that his guidelines were higher than what he thought, then he wanted back out of his plea. So to me, that's not taking responsibility. He took responsibility the day that he entered a plea when he thought his guidelines were lower. And I think that goes along with when I read the sentencing memorandum, in the second paragraph, when it talks about when he was a kid and not being supervised, he got into trouble. Then in the bottom of that paragraph, he was put in a very structured facility, living with his father with rigid rules, and that was too strict. So he rebelled for that. I think Mr. Peterson is a person who does what he wants, when he wants, for whom he wants, himself. And I realize it's not part of the description of the case because it didn't come out at sentence because we didn't have a trial, so the evidence didn't come out. But usually these TNT buys, it's not the first time we set up a buy with somebody. The person knows who they can get methamphetamine from. They know who they can't get methamphetamine from. So I don't believe that this was a one and done incident, although, like I said, that's not part of the record. Speaking with Mr. Van Ackmel, after the reduction of the guidelines, I believe his recommendation would be changed to an 84-month recommendation. I think in light of the guidelines, well, the other thing I wanted to address, Your Honor, is we keep hearing about this being a drug case. This is not what I would consider a drug case. This is not a possession. This is not a use. This is a delivery. It's a delivery of controlled substances. He wasn't found in the car with methamphetamine. He wasn't tested positive for methamphetamine. This was a delivery. That's a whole different bushel of apples than what is construed as, in my mind, a drug case. For those reasons, Your Honor, I'm going to ask the court to sentence the defendant to the recommendation of the 84 months. I'm also going to ask the court to use its discretion in sentencing him as the habitual offender. Thank you.
Thank you. All right, Mr. Peterson, you have the right to make a statement. Anything you wish to say today, sir?
Yes, Your Honor, I just want to take full responsibility. I do take responsibility for it. I just wanted a fair shot in my guidelines, and that's all I asked. But I do take responsibility for the actions that day. I apologize to you, Mr. Wiggins, the people of the community. Most of all, I apologize to my family. But all right.
And we did go through your guidelines, and thankfully we did, because it adjusted it fairly significantly. Took 25 months off, if I recall, or something to that effect. Anything else, sir?
Sorry.
Okay.
I appreciate taking the months off.
All
Take
right.
full responsibility once again. Accept any
Thank you.
punishment that comes with it.
I appreciate that. Thank you. All right, well, let's take a look here at this face. Now the judge gets to do some talking. One of the things that Mr. Harris said was supervision. I look at the defendant's prior criminal history, and not just the criminal history, but his performance on probation and on bond is abysmal. One of them, there was, I think, 8 different violations for testing positive. So we clearly know there's other information contained in the report that demonstrates that the defendant struggles with substance use disorder. But also he had 25 grams, which is nearly an ounce. 25 grams, approximately 100 hits. The defendant's a drug dealer. I'm going to tell you one of the big things here that was a big challenge, a big thing that sticks out to me. He had a tether, cut his tether off. Had the prosecutor chosen, could have added a charge for interfering with electronic communications device. Could have also been charged consecutively because it occurred while you were on bond. The fact that you pled on the day of trial, the court appreciates it, but man, I bet you wish you would have taken one of the other deals prior to this, but it doesn't matter. You didn't, and I don't care, but I'm just stuck with what I've got here before me. I've got a sentencing guideline range of 51 to 127 months. Typically, when I have a plea, I often, as I've already mentioned earlier today, try to start off in the middle. The middle here would have been approximately 76 months. 76 months would be the middle. You didn't take a plea, which is absolutely okay in your choice to do so. And I don't punish for not taking pleas, but I reward people when they do take pleas so they have an idea of what they're looking at.
We did enter a plea, Your Honor.
I know, but he entered a plea without a plea deal.
Right.
But so I appreciate that, and we've got drug dealing. Fine. Had you just stayed clear on Tether, cutting that tether was a huge mistake in the eyes of the court. There is no way you would ever be supervisable. Your criminal history, your history on bond, your history on probation demonstrates exactly as Mr. Wiggins said, you will do what you want to do whenever you want to do it. So, and I've got no problem with somebody choosing to plea on the day of trial or running the trial. But again, I do appreciate that you did enter a plea, and so I'm going to take that in a lot more consideration than I would if you didn't. So, one moment. The court sentences the defendant to a $68 state minimum fee, $130 crime victims' right fund fee. Mr. Wiggins, was there any restitution requested? Like sometimes there's buy money or something involved. TNT has something, but I don't see anything listed.
No, they did not submit a restitution request. But
that's okay. I just normally it comes up.
It would be $300.
All right, that's $300 of restitution, and that's payable to the Michigan State Police Department. Do we call it Michigan State Police, or do we list it under TNT? It's probably Michigan's. Traverse, we'll say Traverse Narcotics Team. All right. The court sentences the defendant as follows, and I'm going to note that the court is exercising its discretion to sentence the defendant as a third habitual offender. The court also notes that this sentence would have been within the guidelines even at a 36 to 90 month period of time, and the court would find it to be a reasonable, appropriate sentence in that instance. But in this particular instance, the guideline range is 51 to 127. The court sentences the defendant to serve 70 to 480 months with 125 days of credit. So you benefited actually quite a bit today by having the guidelines scored down, because that brought the guideline range down to where I can give you something which I thought was actually fair and appropriate based upon the information contained in the pre-sentence investigation report. All right, have I missed anything, Mr. Van Appel? Mr. Wiggins?
No.
Ma'am? I appreciate the bitterness. That's the sentence of the court. Mr. Wiggins, I'm sorry, Mr. Peterson, Mr. Harrison is going to bring to you 2 copies of 1 document. You have the right to appeal the conviction and sentence in your case. It is typically done by filing a claim of right to appeal. However, if you choose to file, because of your plea, any appeal must be done by filing an application for leave to appeal and not a claim of appeal by right. Furthermore, if you choose to file an appeal and you want the court to appoint an attorney to assist you, you complete the bottom half of the document, return to the court within 42 days. If you choose not to appeal, you simply dispose of the document. 1 second. Thank you. Anything further, Mr. Van Appel? Mr. Wiggins?
No, Your Honor.
Mr. Harrison?
Nothing further, Your Honor. May I approach?
You may. Thank you. We're adjourned. Excuse me. Bring them back. Come on back, Mr. Peterson. We don't do that in this courtroom. You can take your seat again. Mr. Peterson, sit down. We are still on the record for People versus Curtis Peterson. As Mr. Peterson was leaving the courtroom, he decided to express his disappointment with the court, and I believe used a couple expletives to state what. Stop talking. You decided to leave, and you said, "Fuck you, people." That's the language. That's what I heard. I said, I don't give a fuck. Whatever. The choice of language, just stop talking. I cannot understand the concept to walk out of a courtroom and start using such language and be voicing your opinion. The court hereby finds the defendant in contempt, sentences the defendant for an additional 10 days that will run consecutive to his sentence in the felony case that we just handled. Thank you. You are now excused. I strongly encourage you to keep quiet as you leave the courtroom.